how our timing is going. And we're recording now. I'm not quite sure how the timing is going to go. So if you could put your chat or your questions in the chat box. If we have time, we will get to some questions and answers both after each of the crimes and then, as you can see, after the panel discussion. And if we can't get to your question today, we'll get back to them if they're in the chat box. Kelly and I will be giving you some information on the structure of the crimes. So I'm going to be talking about the assault of tribal justice personnel. Kelly Stoner will be talking about obstruction of justice. But again, what we're talking about is more the structure of the statute. And our panelists today are going to be talking about possible impacts and implementation of these two crimes. And then we'll do this question and answer, and finally we'll finish up with some resources. So as you remember, in 2013, Congress passed the VAWA 2013, which affirmed the tribal inherent authority to exercise criminal jurisdiction over these three limited crimes. VAWA 22 builds on that framework and adds a bunch of new categories of criminal conduct. Of course, this is all still at 25 U.S.C. 1304, and the tribal part of VAWA 2022 takes effect on October 1st of this year. So what does VAWA 2022 do? Well, one of the things it does is, remember, we've been talking about special domestic violence criminal jurisdiction all this time. It's now called special tribal criminal jurisdiction throughout the law. We've talked about already some discussions about what the appropriate name ought to be, but the code, the statute calls it special tribal criminal jurisdiction. It includes the term covered crimes, and you're going to see that throughout our discussion today and over the other charges as well. It changes what can be charged in tribal court, in some instances, who can be charged in tribal court, and who the victims can be in some cases. So here's what the new covered crimes are. So 2013, we had domestic violence, dating violence, protection of order violations. Those are still part of VAWA 2022. And we talked about that at the last Friday call. And at some point, I think somebody will put the link in to the chat box if you wanted to go back and see that. It's on YouTube. Now, in addition to those first three crimes that were there in 2013, we now have sexual violence, stalking, sex trafficking, child violence, obstruction of justice, and assaults against justice personnel. And those two in bold are the ones we were going to cover today. And collectively, again, these are called covered crimes. So it changes who can be charged in tribal court in some cases. So if you remember, again, in the domestic violence and in the dating violence, they were defined as violence committed. That language is now gone. And it's now any crime committed under your tribal law. It gets rid of what we used to call the sufficient ties. So one of the things was, there was the hypothetical that was asked at the passage in 2013 about, well, if I'm a non-Indian traveling across the country with my native partner, and I stop at a Indian casino and I beat up my partner, could I be hauled into tribal court? And the answer right now is no, because the non-Indian has to live or work in or have a qualifying relationship with a member of the tribe or a non-Indian resident. But under VAWA 22, that's all gone. You won't have to have those sufficient ties. So the person who's just going across the country and beats up their girlfriend or boyfriend at the casino will be covered by these crimes by VAWA 2022. It also clarifies that tribes in Maine can implement the law if they choose to do so. And there are some Alaska-specific provisions. There'll be a pilot project in Alaska, and I think our last Friday call will cover the Alaska provisions. Here is the who can be charged, right? So it used to say that you could only do this if if neither the defendant nor the alleged victim was an Indian. And now that's true for all of those covered crimes except the two we're going to talk about today: obstruction of justice or assault of tribal justice personnel. So if the victim in an obstruction of justice or assault of tribal justice personnel is a non-Indian, the non-Indian perpetrator can still be charged under one of those two crimes. And again, it's effective October 1st, 2022. So let's then get into the assault of tribal justice personnel. And of course, as I just said, that wasn't even a category of crime covered by 2013. So here's the language, and rather than necessarily read this all to you, I'm just going to give you a second here to read it. And then I'm going to sort of unpack it and we'll talk about what it means. So this is the first part of the statute. And then here is the second part. So the first part sets up the sort of prerequisites, and then this tells you who is covered. So the individuals, right, who are doing any of these things, A, B, C, or D, they're the ones who can be the victims of this crime. So I want to take each A and B and C and D and talk about each one of them separately. And we'll have the pertinent language from the first part with that as well. So I'm moving on. So it's any violation of the criminal law of the tribe, right? So any violation of your criminal law that involves the use, attempted use, or threatened use of physical force. So it has to be in your criminal code, and it has to have either use, attempted use, or threatened use of physical force. But again, if they use, attempt use, or threaten the use of force against a person who is authorized to act for or on behalf of or serving that Indian tribe during or because of the performance of duties of that individual. And it's important to note, right? So authorized to act for, on behalf of, or serving that Indian tribe. So it can be an outside entity that is serving the tribe. It doesn't have to be a tribal employee. It doesn't have to be a tribal contractor. Right? It can just be somebody in your county or somebody completely different that's serving the tribe. And again, it's also important to remember it's during or because of the performance. So it doesn't have to be that the person assaults your tribal officer during the arrest. 2 days later, the defendant is out of jail, runs across the officer and threatens him, I'm going to kill you and your family because you arrested me. Okay, that person is violating this crime. They've threatened the use of physical force against an individual because of the performance of duties of that individual. Okay. So again, preventing, detecting, investigating, making arrests relating to, making apprehensions for, or prosecuting a covered crime. And it's important, I've underlined covered crime because it's not any crime that this would work for. It's only one of those listed covered crimes that we talked about before in that previous in that previous slide. So if you were to arrest, well, anyway, right? So it's got to be a covered crime. So who's going to be doing that? Well, let's look at one of those covered crimes. One of those covered crimes is child violence. Who's going to be preventing, detecting, and investigating a claim of child violence? Well, it's going to be your police, but it's also going to be your child welfare people, right? They're going to be preventing, detecting, and investigating a crime of child violence. So your child welfare worker may well be the victim of this, and that would be because of preventing, detecting, investigating during or because of their actions, and it is a covered crime. So you could charge the defendant then with assault on a justice personnel if they use, attempt to use, or threaten against that child welfare worker. Okay, also it covers those who are adjudicating, participating in the adjudication of, or supporting the adjudication of a covered crime. So this is going to cover all of your court personnel, essentially, but also, you know, the attorneys, witnesses, anybody else who's involved in the adjudication, essentially. It also covers those who are detaining, providing supervision for, or providing services for persons, excuse me, charged with a covered crime, okay? So they have to be charged, and it has to be a covered crime. Then, if they are detaining, providing supervision, or providing services, who's that going to be? Well, obviously, corrections. But do you have a nurse in the jail who does a health screening for people who've been charged? Do you have in-jail educators? Do you have in-jail personnel who do cultural activities in the jail? If any of them have force, attempt to force, or threaten force against them by the non-Indian, they would be violating this crime. Oops. And then finally, part D is these are for convicted persons, okay? So the last one was covered persons. This one is convicted. It's going to cover many of the same people. So it's those who are incarcerating. So all of your corrections personnel, whether they're correctional officers or teachers or anyone else who's doing incarceration, anybody who's supervising the individual, the defendant. So probation and parole, providing treatment. So mental health, providing rehabilitation services. This might include things like, your tarot. It might be mental health. It might be a batterer's intervention program. So they don't have to be incarcerated at this time. They just have to be convicted. But while they're in jail, the jail people are covered as well. And then I have a couple of sort of examples of some codes that I found that are at least kind of falling within this assault of a justice personnel already. So here's one. So it's unlawful to commit an assault inflicting serious injury on a law enforcement officer, probation officer, parole officer while they're discharging or attempting to discharge their duties, or unlawful to commit a simple assault on a law enforcement officer while the officer is discharging their duties. So notice here, though, that it's partly it's how do you define assault? Is assault defined as the actual use of force, or is it also the attempt or threat of force? If it's defined broadly in those three terms, then at least that part of it is covered, right? Also, notice that it's while they're discharging or attempting to discharge their duties, right? But not the during or because of, which is covered under VAWA 2022. So this says while they're doing their duty if you assault them, but doesn't cover the afterwards if they assault them because of them discharging their official duties. So that would be a change that would be needed in this code. Here's one for its emergency medical technicians, medical responders, department nurse, emergency department physicians, firefighters. And again, these people may all be included. And again, we're going to want to look to see what is the definition of assault. And we also then want to be able to do the during or because of language to make sure that even after they have discharged their duties, you're covering them. Here's another one. So protection of government officials. So here it's in assaults, intimidates, or interferes with. So again, how is assault defined? But intimidates or interferes with may or may not rise to the level of a threat or attempted threat of use of force. So again, it depends on how they intimidate or how they interfere, because then it could in fact be using use of force in that. The other thing is that if they interfere with them, that's probably going to be covered by the obstruction of justice code sections that Kelly Stoner is going to talk about here in a few minutes. All right, so notice here that it's down here at the bottom, on account of the performance of official duties or while such member is engaged in official duties. So this does cover the because of the performance language from VAWA 2022. And then one last example, and again, these are just examples. We're not saying any of these are necessarily good for VAWA 2022. And in fact, I'm pointing out some things that may need to be changed in each of these, but there's nothing necessarily wrong with them now, but they may have some problems if you wanted to apply them to VAWA 2022. And here's the last one that I think, no, I'm sorry. So this is the custodial assault one, right? So again, here it's a staff member volunteer, right? While they're performing their duties, or in C2, assaults any other full or part-time employee. And again, remember that VAWA 2022 does not require them to be an employee. So it can be broader than that. It doesn't have to be a staff member. Okay, it can be some of these other people that are listed up here in B. And then this one, I'm not sure exactly how it's being interpreted now, but if the ands are truly conjunctions and are not meant to be separate ways in which you can commit this crime, you can see that right now you'd have to use force intentionally to injure them. They would have to have medical care. They were making a lawful arrest and you knew the officer was a law enforcement officer. If those are conjunctions, then you at least have some information now that could be useful, but you would still need to make some broader changes here, just because you also want it to be the because of their performance. So you might want to make some changes to this code as well. There are some other kinds of things that I found when I was looking through tribal court or tribal codes. So I found some where there are actually assault on government employees, but again, remember it's broader than that. Resisting arrest or retaliation against a witness. So some of those codes would also fit under this code section, this VAWA 2022 assault of tribal justice personnel. So again, you might have to look at your code and try to figure out what's going on. So here's some things to think about. So again, you know, it's any violation of the tribal criminal law that meets the VAWA 2022 definition: use, attempted use, or threatened use. It has to be over, you know, a covered crime. So what changes are you going to have to make? Do you want to define tribal justice personnel? And you may want to just leave it the way it is in VAWA 2022, just because if you try to think of everybody who might possibly be a tribal justice personnel under the broad language of the statute, you may miss somebody if you try listing them all out by job titles or something. You also then means that you should probably make your service providers aware, right? So now if they get a threat, it's not just, well, you know, the non-Indian dad made some threat to me and I make it in my report to the court. It's now a crime. And if the crime that you were investigating was this child abuse, right? So you might want to think about making sure all of your service providers are aware. Anybody that has a service that goes to either an incarcerated, a charged, or a convicted non-Indian, you might want to make them aware that this could go. Can you use your current code without changes? You might be able to, but be careful that you are making sure that you have all of the necessary elements in your complaint, and that the code actually does cover the thing that happened. Also remember that for this crime, your victims do not have to be Indian. Your victims can be any of those people who are acting on behalf of, or for, or giving service to the tribe. So Indian, non-Indian, doesn't matter. So at this point, I think we're going to stop recording and open it up to see if there's any
overview of what obstruction of justice is. And typically, we're going to find obstruction of justice crimes in the federal system, several of them. We'll find those in the state system. And then as I move through, I'm going to give you some tribal examples that I went through and pulled out just for you to get some sort of reference. You may already have a form of obstruction of justice in your tribal codes, but typically what this crime means is to interfere with the proper operations of the justice process. They can be civil or criminal, but VAWA 2022 focuses on the criminal, the crime of obstruction of justice. And usually these types of crimes require a willful act that is intended to thwart or impede or obstruct the criminal justice process. Some of the acts you might see covered by obstruction of justice crimes would be threatening of the judges or a judge, threatening of a witness. When I was handling domestic violence crimes, you can just go back to the other slide there, Kat. When I was handling domestic violence crimes, for instance, it was not uncommon for a criminal defendant to keep the witness, the victim, from coming in to testify, let the air out of her tires, or to threaten the individual who was supposed to transport that victim witness to the trial. So that is just an example. Destroying evidence, hiding evidence, lying to a tribal justice personnel, such as a law enforcement officer, or when the law enforcement officer is asking this individual questions, they leave out material facts that would be really important to the investigation on purpose to impede the investigation. Also assisting, hiding someone who's been charged with a crime, or helping someone to escape. In some jurisdictions, this crime of obstruction of justice also covers tipping off an individual that is the subject of a criminal investigation with the intent to either have that person flee or to thwart or impede, present an obstacle to the investigation. So again, that's just a broad overview generally of what this crime might entail. And you'll see some jurisdictions, such as the federal jurisdiction, having numerous crimes that fall under obstruction of justice, and they might be for a particular act or a particular discipline. So with that, let's go to the next slide. And just to reiterate, VAWA 2013 did not include obstruction of justice as a category of crime that authorized or reaffirmed a tribe's inherent sovereign authority to criminally prosecute non-Indians. So we do get this. This is new. And let's go to the next slide. I want to provide you with the actual, this is the definition from 25 U.S.C. 1304. I'm going to unpack this for you, but I wanted you to have it there because we'll post these PowerPoints, this slide deck, so you'll have this handy. So let's go ahead and begin to unpack this. This is a very interesting crime too, because both the crime that Steve just talked about does not require, it's one of two, and this is the second, does not require an Indian victim. And as we're moving through this, I just want to ground you a little bit. We're talking about prosecutions of non-Indians committing this crime in Indian country. Again, can be an Indian victim, can be a non-Indian victim. Maybe there isn't a victim. Maybe it's the justice system that's the victim. So this is very unique, that the two crimes we're talking about today. So here's the first thing I want to unpack for you. Again, obstruction of justice is the crime. Any violation of the criminal law of the Indian tribe. So this is super interesting, and we keep seeing this in many of these, most all of these covered crimes. Congress defaults to tribes to set the elements of this crime within certain parameters and to really decide whether or not in their tribal communities they want to prosecute this crime and the issues that need to be addressed in the tribal community with the prosecution of this crime. So first off, defaulting to Indian law, to tribal law. And it has to be the tribal law, of course, where this violation or this act of thwarting the administration of justice or the criminal justice process occurs. Now that one I think is fairly straightforward, so let's remember that and go to the next slide. Still unpacking obstruction of justice here, because this is such a broad sweeping crime that I think perhaps what you're going to want to do is go back and look in your criminal tribal codes and see if there are any crimes there that might qualify as obstruction of justice. So that's going to, I think, be your starting place. And that the tribal criminal code doesn't just say only Indians can be prosecuted for this, because this is opening it up to non-Indians being prosecuted. So the second piece of unpacking I want to do here is this. This act, that involves interfering with the administration or due process of the laws of the Indian tribe. See how broad sweeping that is? I don't know what's in that box there, interfering with the administration or due process of the laws of the Indian tribe. That could be big. That could be broad. Including, we know in that box, whatever's in there, it includes any tribal criminal proceeding or investigation of a crime. That's your safe zone. We know that it includes that, but it might include more. So let's go to the next slide. I do want to say a little bit about administration or due process for those of you who might not be that familiar with this crime. Typically, that means that you are impeding the process, the flow of the criminal process as the tribe has set it out in its codes. You are somehow impeding that from taking place according to the ways that the tribe has outlined that these criminal cases need to flow, need to take place. So I also want to point out to you too, I think this is really interesting before I go through the tribal examples. When you think about this crime, obstruction of justice, it does not, according to the language that we are given in VAWA 2022, it does not have to be tethered to a covered crime. That's big. Maybe your tribe will say, ooh, that might be flagged for litigation. We don't know. Maybe it's the safest to tether it to a covered crime. That's a sovereignty issue. But I think it's really important that covered crimes are not mentioned at all in the definition of this crime that Congress gave us. So what you could have technically is some scenario where there's an investigation of a defendant for something, and the family member impedes the criminal process by threatening a witness. That family member, non-Indian family member, because tribes can already prosecute Indians. So the non-Indian that is impeding this process could be charged with this crime. This is broad sweeping. Again, dependent on what's going on in the tribal community and what the tribal professionals and tribal government feel the best way to address obstruction of justice in the tribal community. But on its face, it's broad sweeping. So let's take a look here at some tribal codes. I selected from a group of codes. Again, these are not model codes. These are pre-VAWA 2022, just giving you some examples of what's already in the tribal codes now. So this one we see in Tulalips, and there's a definition. It's called obstruction of justice. Knowing another person is an offender, this person that's committing the crime of obstruction of justice is harboring or concealing or warning that person that's charged with impending arrest or all those sorts of things, assisting the defendant to run from the criminal authorities. So you can kind of look down into that grouping there and get an idea of what Tulalip already has in their tribal codes, because that's one of the issues we're going to have to talk about. Can you use existing codes and simply plead and prove some additional jurisdictional facts as a part of your criminal case to bring this within the realm of VAWA 2022? So just want to get that out there. Next slide. Gonna hurry through these. I think the next one is Tulalip as well, but notice this one, and like I was telling you in the federal system, there are several obstruction of justice type crimes. So this one is obstructing a law enforcement officer or other tribal public servant. This is a crime. It tells you the elements of the crime, and it also lists a defense there. Next slide. The last slide, I think, is Fort Peck. And again, this is not called obstruction of justice, but might fit within the definition of obstruction of justice. And again, we talk about pleading and proving additional facts so that all tribes don't have to go back in and revamp their codes. If you need more information on pleading and proving jurisdictional facts, please just reach out. Again, this one is hindering law enforcement, talks about how the acts that have to take place to qualify to be charged with this crime. So again, next slide. I think you're going to see different, Eastern Band of Cherokee. So I have 4. Okay, this one is about hindering the apprehension, prosecution, conviction, or punishment of another for the commission of offense. Again, someone has committed a crime and there's a lot of assisting, trying to hide them, help them escape, warning that person that of investigations and those sorts of things. Okay, next slide. As you go back and look at your codes, again, we know not every tribe is going to be able to revamp their codes if they've already done it, or if they don't have the resources. They feel like what they have on the books will work by pleading and proving these facts to bring the crime on the books within the purview of VAWA 2022. Go look, and you may see things like hindering law enforcement, resisting, delaying, or obstructing officers, obstruction of the performance of police duties, resisting arrest. All of those are impeding, thwarting, frustrating the tribal criminal process. Next slide. Points to ponder. I probably have already asked these questions of you all. Again, going back and thinking, looking at your codes, your criminal codes. What do we have here on the books we might be able to use now? Will you need to make changes? Is it okay? Does it meet any sort of requirements that were given in VAWA 2022 definitions? If not, can we use what we have on our books and plead and prove additional facts in this criminal case so we don't have to go back and revamp our codes? So again, if you need information on that, please reach out. Next slide. And this is the question and answer session. If you want to stop for just a second, we'll take a couple of minutes. If you have no questions, I'm going to move right into the panel discussion. And I would like to introduce the panel members to you today. Megan James, who is a tribal prosecutor for the Tulalip Tribes of Washington. Dawn Stover is now the executive director of Alliance of Tribal Coalitions to End Violence. Before that, she was an ITWIG member through the Native Alliance Against Violence as that executive director. So she's been with the program for a while. And a good friend of mine, Michelle Rivard Parks, associate director of the Tribal Judicial Institute at the University of North Dakota, who is here today in her expert capacity of advising tribal law enforcement and probation and tribal reentry programs. So with that introduction of everyone, I am going to be asking some questions of the panelists. And Megan, I'd like to start with you. If I can get you to explain or share with us Tulalip's approach to implementing these two crimes.
Yes, so here at Tulalip, as Kelly and Steve were explaining, these are two of the broadest additions to tribal jurisdiction under VAWA 2022, especially the anticipating that when we start charging these different crimes, that specifically obstruction of justice crimes really could be the biggest increase in our caseload if we were to charge any crime that fit. So some of the things that we're doing to prepare for this is working with our law enforcement to get an idea of police contacts that our law enforcement is having with non-Indians right now, and the amount of charges that are getting referred to our county counterparts for obstruction related crimes. And then also thinking about all those obstruction related crimes committed by non-Indians that are never reported because they're linked to things that we prosecute. But because we know that the county is likely uninterested in charging these crimes, that really they're just not even reported in the first place. So there's just really potentially a lot of incoming cases that could be coming from these two areas. So Kelly did reference a couple of our laws that we have at Tulalip that I think will fit within these new crimes. We actually have a whole code section in our criminal code titled Offenses Against Public Administration that I think has a lot of different crimes right now that will fit within the obstruction of justice section of special criminal jurisdiction. And our codes are publicly available online. If anyone wants to Google that and take a look at them, they're on a website called Code Publishing. And so because we think that there's going to be so many new potential things we could prosecute, once we have an idea of kind of the numbers, things that we've been thinking about for deciding when we're going to exercise our jurisdiction and maybe when we're not, is thinking about doing filing standards for our office or adding additions to filing standards about when we will exercise jurisdiction over both of these areas of crime. So if our officers are investigating a crime that we don't have jurisdiction over and they get assaulted or they obstruct by lying about their name or providing false information, are we going to prosecute that, or is the county going to take that because it's already connected to a crime and a report that we don't have jurisdiction over? So in cases like that, we want to have those conversations with our county counterparts about, does it make sense to split up a case, an incident like that? Are you going to charge the drug possession and we're going to charge the obstructing, or are you going to charge everything? I think most of the time it will probably make sense for county to charge everything when it's connected to a crime that we don't have jurisdiction over. But then also in Washington, we're kind of in an interesting position right now where the Washington state drug law was invalidated by the Washington state Supreme Court. So a lot of times when our officers are having contact with non-Indians for drug crimes, those aren't even prosecutable by the state. So if those people are having contact with our law enforcement and lying about their name or trying to obstruct, then that's the only crime that can even be charged at this point in Washington. So I think we would definitely want to take all of those because we don't want the impression that you can come with your drugs on our reservation, lie to our police or assault them and have no consequences. We want them to take that behavior elsewhere. And so other things that we're doing is just looking at all of our laws, trying to expand jurisdiction as much as possible. If we need to make some tweaks, we will definitely be taking the same thing that Brent's doing at Umatilla. We'll be pleading and proving jurisdictional facts, not writing in whole code provisions to try to encapsulate those jurisdictional facts because, well, we actually did that for VAWA 2013. We kind of just like copied in the entire language of the VAWA for like the sufficient ties and things like that to prosecute non-natives. And so now we're stuck with a code where we have limited ourselves for jurisdiction to only those people that qualified under VAWA 2013. So we're definitely going to have to make those changes and remove that language before October so that we're even able to exercise additional jurisdiction for VAWA 2022.
Megan, thank you. Could you say a few words about what kind of training is going to have to go on there to get everybody up to speed on exercising obstruction of justice or assault on tribal justice personnel on October 1 or shortly thereafter?
Yes, so I think there's definitely going to need to be some training for law enforcement and for other service providers to know when they need to be reporting or referring things to our office versus the county. So different things that we've talked about for our law enforcement is maybe we'll end up making kind of like a cheat sheet that they can carry in their pocket or in the things that they usually carry in their car, going through our code and pulling out specific code provisions where if you're charging someone with these different codes, then those now get referred to the tribal prosecutors instead of referring it to Snohomish County prosecutors. And then I think we're definitely going to be doing a lot of outreach with our service providers that frequently interact with the court. So Tulalip Family Services that does mental health and chemical dependency, any treatment providers that do the DV batters treatment, our Children's Advocacy Center and our Legacy of Healing, people that have frequent contact with our victims. We'll be doing a lot of outreach and training about what now comes to us, because one of the main things that we like to do, and that I think will be great with the addition of all this new crimes that we can charge, is tribes often are able to act so much faster than the state or the county. So we want to be responding to crimes and reaching out to victims as fast as possible. And that's only going to happen if people know that they need to be reporting and referring to our office. Because if it goes to county first, and then there's a jurisdictional mess about, oh, do we really have jurisdiction or do you, then it ends up taking so much longer. So we'll definitely be doing a lot of outreach and training so that people know what needs to come to us starting in October.
One follow-up question. Again, if you have questions for Megan, you can put them in the chat box, and we'll circle back and try to address all of those. But Megan, before I move on to Michelle, you mentioned that you had, sort of copied the federal sufficient ties of VAWA 2013, and that now exists in your tribal criminal codes. Do you know, and I don't mean to put you on the spot, is it difficult, is that a difficult maneuver to have that removed at Tulalip, or do you anticipate that could be done rather quickly?
I think it can be done rather quickly. Usually for quick changes like that, our office is able to do the changes and get it to the board for approval within a month or two of our board sessions. But I think for a lot of tribes, when it's usually like prosecutors that are changing criminal codes, it's just the time to do it. We're always so busy that taking time to go back and fix things like that just takes time. But luckily, I mean, I guess it's kind of a happy accident that we have till October 1st to get all this stuff in order. So I think we'll definitely have it fixed by then.
Well, thank you, Megan, and don't stay with us because I may circle back to you. And just to sort of re-emphasize that tribes can use their existing codes and plead and prove additional jurisdictional facts without having to do, possibly a major overhaul. But when you have those sufficient ties from VAWA 2013 in your code, those apply until that code gets amended. And that has to be, again, they won't apply till after October 1 of 2022. I'd like to ask Michelle a question next. Michelle, what kind of collaborative agreements with respect to law enforcement and probation might be useful for those tribes that are, like we just heard from Tulalip, they're going to have some crossover with the state. They've got maybe non-Indian defendants moving back and forth across jurisdictional lines.
Well, I think collaborative agreements are going to come into play in a couple of realms. We're going to see, I think we've already seen an increase in recent years with tribes and states moving towards collaborative agreements with law enforcement. But one area I think that's also going to come into play here is going to be collaborative agreements with probation departments relevant to the supervision of offenders, so that we are able to supervise offenders in areas where they live. And I think these collaborative agreements are twofold in terms of the purpose and rationale behind them. But a big factor is just a simple lack of resources or manpower out of both of those jurisdictions. I think that's in part why we're seeing that. And I think when it comes to these special tribal provisions, we may see some of that as well. So if we have an offender, for example, who lives in a neighboring city, but who commits a crime within Indian country that is one of these the covered crimes, then it comes down to who's going to supervise that person post adjudication, right? Are we going to conduct the supervision of that through our probation departments at the tribal level, or are we going to maybe have a collaborative agreement where we work with a neighboring county or state probation department, for example, to supervise that offender? And then there's a whole host of questions that can come about with what happens if there's non-compliance, where would that be reported to? But those are all things that can certainly be addressed through those collaborative agreements.
More questions for you, Michelle. I know we had a conversation getting ready for the webinar, and we talked about what you saw as very important pieces if tribes are going to go back and draft codes, and some of that had to do with definitions. Do you want to expand on that?
Sure. Particularly for the topic of what Steve was talking about with the covered crimes relevant to tribal justice system officials. I think that we have a tendency, and I don't mean we by those of us just working in tribal communities, I think just, nationwide, and dare I say maybe even globally, we've got typically a fairly narrow view of tribal justice system officials and who might constitute a justice system official. So I think one, I guess, tip or suggestion I would have from a tribal code perspective is to take a look at whether or not your tribal code defines tribal justice system personnel and how you define it. And I know, Steve mentioned, be careful of just doing the laundry list by title for a couple of reasons. Number one, that can result in limitations for, who is going to constitute. And I think number two for that is that I just lost my train of thought on that. Sorry. Who can, sorry, we don't want to be restrictive in our code. But also, I think when it comes to tribes in particular, we're seeing a lot of movement in towards incorporation of cultural practices and programs. We are having a lot of diversionary programming. We have a lot of different people that are working with court-involved individuals. And that may include supervising and providing services to non-Indians now that we are exercising criminal jurisdiction over non-Indians. So making sure that when you're looking at how you define tribal justice system personnel, somewhat of a laundry list is okay, but I always suggest some sort of catch-all provisions, right? So that you can capture maybe those cultural mentors who are working with offenders post-adjudication, so that you are capturing the people that are working in your probation and reentry departments. And just one last thing on that code piece. We've been doing some work. I've been doing some work with the Tribal Probation Academy folks out of NCJTC. And one of the things that we've noticed with a lot of the tribal probation departments is that codes with respect to tribal probation are oftentimes very limited. We're just now starting to see a lot more code development in tribal codes relevant to probation. And I think that this also is something that if people are revisiting or looking at their tribal probation provisions, to make sure that they're looking at that in concert with VAWA 2022. Because our probation officers are going to be providing oftentimes both supervisory roles, which would be covered, and then also maybe performing a certain degree of investigation roles as well.
Let me ask you this, Michelle. It just came to my mind as you're talking about the code drafting. Would you agree it might be really beneficial if tribes are going to go in and alter existing codes, or even to amend, create new codes, that not only with assault of tribal justice personnel that you just went over, but with obstruction of justice, to make it clear, although it seems clear to me, but writing it down always makes it clearer, that the crime of obstruction of justice continues until that sentence has been completed. In other words, it makes it clear that if there's any obstruction during the probationary supervision, that will fall within the realm of obstruction of justice, instead of just leaving it to what everyone would know that.
Yeah, I think that, making some of those points of clarification is important. And the other thing I feel like in a lot of our tribal code arena, I think that having some measure of legislative history or a purpose statement that makes some of those points clear within our tribal codes can be really helpful to us as prosecutors or attorneys who might, and to the judges as well, as they're interpreting and applying the law, right? I serve on an appeals court here with one of the tribes in North Dakota. And, we look at some of these laws and we're trying to apply them on appeal. And oftentimes I wish we had some of that legislative history that was captured. So I think the purpose statements and the definitions within tribal codes is important from a tribal code development standpoint. But I also think when you're working with your tribal councils or your tribal leadership, developing a good process to capture some of that legislative history that, really gets to the tribe's discussions and the tribe's point of view can also be a really useful tool when we get to the adjudication of these crimes.
I also think just kind of, and then I'm going to put Dawn on the deck here, but Michelle, I may come back to you. As a former judge for 8 years for a tribe here in Oklahoma, tribal judge, I wasn't from the community, and I can't overemphasize how important the findings or the purpose section that Michelle is referring to. I can't overemphasize how important that was to me, because I wasn't familiar, just superficially, I wasn't familiar with the customs, traditions, even the intent, the goal that a particular set of tribal statutes, what goal that the legislators were trying to achieve. And when you have that to go back and read, I've seen lately, as I've looked at different codes, saying it is the intent of this section of the tribal code to be liberally construed to meet the objectives that we've set out above in the purpose. And I just find that really helpful.
Yeah, I think that's helpful from an adjudication standpoint. And, the other, just kind of one thing, and then I'll certainly going to turn this over for Dawn. One other thing I think that is important too is when we're in terms of like these defining tribal justice system officials and things like that, and how comprehensive do we have to be in our code amendment process. So we saw some earlier examples that Steve laid out of like a lot of tribal codes will have like assault on a police officer, violence against a police officer, and it's a good code, and it certainly meets the criteria here, but it's also narrow. And you could go through and put assault on a PO, assault on this person, assault, or you can simply look at that and say assault on, remove the law enforcement reference and say assault on a tribal justice system official. And then earlier you could define tribal justice system official in a kind of expansive and broad way. And I think if in that way, you may undertake some code amendment, but it doesn't necessarily have to be this big sweeping process.
Right. I think tribes might be happy to hear that, because some tribes are just now having their codes reviewed to implement SDVCJ, the 2013 version. So yes, I think that's really important. Thank you. And Dawn, I'm going to move to you, and I'm going to ask you this question. Can you anticipate, or have you in your experience or anecdotally, do you have any idea how the prosecution of these two crimes we've talked about today may promote victim safety? And you are the victim advocate voice here.
Thank you, Kelly. You know, I think we've thought about all of the reasons why victims participate in a criminal justice action and all of the reasons why a victim might not want to participate. And oftentimes that comes down to safety. So I see these two crimes creating a landscape where folks will be held accountable for the threats, physical threats that they're often the focus of, them and their families, their supportive networks that might be around them. So I think as I've heard before victims say, I'm not going to go through with this case because you can't protect me. You can't keep me safe. And perhaps when they saw in VAWA 2013, where there were assaults on tribal court, personnel or justice personnel that went unanswered, or, they were not held accountable for that, it probably did send a message that maybe they weren't able to be held safe by the courts or the criminal justice system. So I see this as being just another reinforcement to the network that's around them, that that it also sends a message out into the community. You have victims who have stated that their perpetrator knew exactly what the system was able to do and what they were unable to do, and that they used that information then to beat and maim them with impunity. So, I feel like every little measure that we move towards a safer court, and those working within the court system, those working within the tribe to respond to these crimes, creates a safer environment for the victims.
So let me, Dawn, as I began to work through this, unpack the obstruction of justice covered crime in VAWA 2022. Of course, given my background, my mind began to race to the domestic violence incidents. And I find it just, first of all, I didn't know that I would ever see the day that Congress keeps saying, well, tribes will define this. And they define it within the parameters here, loose parameters, but tribes are going to define this on their own to meet the needs of their tribal community. I began to think of all the times that I would have, as a tribal prosecutor, prosecuted obstruction of the non-Indian. I mean, I didn't even, back then, we weren't, we had the restriction of Oliphant. But now, not only can we prosecute the non-Indian, but we can prosecute the non-Indians committing this crime that had maybe nothing to do with the crime that the non-Indians being prosecuted. In other words, the non-Indians that are impeding as the victim, is moving through that criminal justice process as a victim. Do you think I'm assuming you think that's empowering the victims, and any other benefits you see coming from that?
Yeah, oftentimes family members are used as a tool by the perpetrator to further intimidate, threaten, and coerce the victim after the perpetrator's being held accountable for the domestic violence crime. So you see that they have a group of people that will threaten. And it was common for victims to have family members, their supportive folks, not want to get involved in their cases because they had seen the violence committed. They knew what the person was capable of, and they certainly didn't want to, put a bullseye or a target on them. And I mean, we even saw that when we were doing civil legal assistance program at the NAV, where there were times when our attorneys had been threatened, who were going in for a civil protective order to stand with the victim and represent the victim. And threats had been made against the court. Threats had been made against the attorneys. I mean, we went to a higher safety standard in our office knowing that at the point in time a perpetrator starts losing control over the victim, their target becomes wider, and anyone who's assisting in that becomes also a target. And so, I did, I had that kind of same reaction, but I'll tell you, I'll delve into a little bit of what I called my aha moment. And I know I thought about this, but probably not as much as I had in hearing Steve and you speak. And we've seen a lot of times in cases of domestic violence, or even in child abuse cases, where a victim is used, or a victim is put into a position by a court where they're charged with various crimes for their failures as a result of the bad acts of a perpetrator, right? So I was thinking about the obstruction of justice, and then I was like, oh, there's a cautionary tale there. VAWA 2013 and VAWA 2022 is centered on victim safety. That's the whole purpose it exists. And the reason why we moved to restore the tribe's sovereign rights to prosecute non-natives is because they weren't being prosecuted, rarely being prosecuted by the United States Attorney. So Native women are at the center of those laws. And I think as in our excitement about moving forward and being able to prosecute these crimes, that we make sure that we're not thinking that the victim might also be charged with these obstruction of justice, that instead we need to think about why it is that a victim might not feel safe in coming to court, or why they might recant. Those are all, that's a trauma-informed court. And so I feel like that's really a space that we need to maybe ramp up some training on and talk about that. And with regard to children who might be abused, we have to also think about the protective measures that a non-offending parent goes through to protect the children. And sometimes that's staying within that violent situation until the services and the supportive services are available. And, for the longest time prior to VAWA 2013, until the court system was there supporting these victims, that they're able to leave those violent homes. And so I always say, if we can get the non-offending parent safe, so too will those children be safe. And so we really have to think about the victim safety, not just from the courtroom safety, but of all of the ways in which they may be woven through that criminal justice process. And then one last thought that I had on that was, the tribal justice personnel, those are your advocates too. In some jurisdictions, your advocates, particularly in high lethality cases, they're responding at the request of law enforcement at the scene. And so we need to, that they may also be part of that, somebody who may be receive those threats, and likely they would be. So just so many things to unpack. Every time we have these meetings, I swear the brain is just working, and I always walk away with a lot more questions and thoughts and considerations and things that we need to focus on and make sure that we're not, following some of I always say the bad acts of the state. The states gives us a lot of reason to say, we're not going to do this, and we're not going to do that, and we're not going to do that. And that would be, charging victims with that obstruction as well. So, and I feel that I trust our tribal courts not to do that, because obviously they're starting from a standpoint of a trauma-informed. That's the reason why we're here. That's why we got, 2013 was to make sure that victims were served. So I don't want to leave that out there like I think that tribes would do that, but sometimes it's in our desire to move forward in a criminal justice system, we can sometimes forget the victim safety, and that should be something that we revisit at every step.
Great lead into my question to you, and then I'll maybe ask everyone that's on the panel, I'll ask the same question to them. But Dawn, I was just thinking, as tribes are gearing up possibly to make some amendments to their code, it might be a great time to revisit their victims' rights code, give that a good look. Do you want to talk at all about how important victims' rights are to a victim who's having to navigate the criminal justice system?
Absolutely. So, victim rights, I've read a lot of victim rights codes, mainly state victim rights, and a victim right that says you have the right to this and you have the right to that, and we're going to notify you and keep you informed in the process, and we're not going to offer any pleas before we talk to you, and you're going to be informed all the way. But then I see state courts not adhering to those rights, and there's no punitive measure as a result. So when you report back and you say, wait a minute, these victim rights were not protected, there was really never a process for reprimanding a court that failed to acknowledge or protect or adhere to the rights. So I'd say when you're thinking about the rights, you should obviously have victim advocates at that table, as well as, of course, the legal minds in doing that. But then think about, so is it just lip service, or is it truly the right? And the federal government does they have very strong victim rights, and they have very strong measures for what happens when those rights aren't followed. So I would say that's really important. And I think that we can learn a lot from victims who didn't feel that the criminal justice system ally of theirs, but instead they were kind of an uninterested party, that probably would tell me that they didn't have strong victim rights, because truly your victim can oftentimes tell you what justice looks like to them. And I see oftentimes where cases are pled down with somebody who's had multiple, and again, I'm talking about, I'm using state court as the example here, where they have multiple domestic violence charges and they have no convictions, but they're getting like disturbing the peace, or they'll plead it down to something that really doesn't sound very serious, and they do so without the victim. And it may be that that would have changed a prosecutor's mindset. So I think victim rights codes are just critical. And oftentimes the missing link to making sure that you have that holistic criminal justice system that's serving the victim.
Thank you. And I just want to emphasize the enforcement mechanism. If you have tribal codes with no enforcement mechanism, they're vulnerable. In order to really make those rights, someone needs to be responsible for making sure those rights are being followed, and possibly even someone to report violations of victims' rights too, so that you can at least get some monitoring done. So Dawn, I'm gonna ask you all three, but Dawn, if you're still there, and you were breaking up just a tad, so I don't know if you might want to turn off your camera. I just will ask the panelists, we have about maybe 5 minutes here. If you could name one or two critical areas of technical assistance that might be needed to implement VAWA 2022, one or two, what would those be? Dawn, you want to talk about what the advocates might need?
Yeah, so I would say probably there needs to be what I call a multidisciplinary training. So having law enforcement, having prosecutors, judges, advocacy, and perhaps child welfare or social service, having all of the players at the table. So for kind of a baseline domestic violence, sexual assault, whatever it is, so that everyone is being trained on this at the same place, right? So they have the common working understanding, and can really learn from each other on those disciplines. So I would say probably a multidisciplinary training approach to these crimes.
Okay, I will come to Megan. Megan, what do you see as maybe one or two of the TA needs, the training needs, if you will, for Tulalip to implement?
I think for us, it's going to be either ideas or training for tools to make it as easy as possible to understand the new law provisions for law enforcement and then our community-based advocates, because those are the people that are going to be having first contact with our victims. And I will say for us, for like VAWA 2013, one of the things is, and we do sometimes get these, we get referrals for DV incidences where there are no close contacts to Tulalip. It's maybe someone that was staying at our hotel and casino. But when people in the field are having those contacts with victims and they're setting the expectations for a tribal prosecution, then when we're having contact with victims, they're expecting like fast moving tribal prosecution. Like, what can you do to help me right now? And we're like, oh, sorry, we don't have jurisdiction. That has to go through the state. And unfortunately, it's probably going to take a really long time for anything to happen. So I think it's really important for our community advocates and law enforcement to have a good understanding of the new provisions so that they're able to set the stage and set expectations for our victims.
Great, thank you. Michelle, what would be one or two of the critical training needs that you envision with respect to law enforcement and prosecution, probation, reentry?
Well, I think, just the biggest baseline need is going to be for tribal, a resource that, whether that's some sort of a written resource or whether it's training opportunity, so that law enforcement and probation gain an understanding of the special tribal criminal jurisdiction, and then an understanding of what their role might be within that. I think that's one big area. I think another area moves more towards the tribal self-governance side and tribal leadership, because a lot of times they will, as well as the justice system of professionals that will be involved with negotiation, but understanding how collaborative agreements might be impactful for implementing the special tribal criminal jurisdiction. And then the last thing that I wanted to say, just real quickly off of Dawn's comment too, about respecting victims, and when you were talking about victims' rights and enforceability and making sure the victim's voice is heard. Another thing that I think is, when we look at special criminal tribal jurisdiction or even the special DV jurisdiction that came before, we've got a lot of tribes that are hiring attorneys that are licensed attorneys that may not be real familiar with the tribal communities that they're serving. And so I always think that having some resources or tools that can help those within your justice system to attain a measure of cultural competency is really important to protecting and enforcing victims' rights and voice.
Thank you. And I want to say thank you very much to Megan James, Don Stover, and Michelle Rivard Parks. Great panel, great information. Thank you all so much for being here. And I will turn it now over to Chia with TLPI to go through the resources we have for everyone and give us some final comments.
Okay. So just real briefly, we have a couple resources. TLPI has some, and the NCAI Tribal VAWA resources here. And I do want to mention that we will be sending out this PowerPoint to those who registered, so that you can see the links here and click on them, so we don't have to spend all the time right now going through them, since we're just trying to finish up here. So next slide, please. Also, the tribalprotectionorder.org site that TLPI has set up, so that's another great resource. And as well as a TLPI website, walkingoncommonground.org. And just to mention that we do have the recording from our first facilitated discussion, and we will this one's being recorded and we will post it as well. And then the PowerPoint is available for last discussion and this one as well. And I promise I'll send out all the links next week. And this is just briefly some work that TLPI does on tribal state collaboration. And again, you can contact TLPI if you need any resources, and here's some more TLPI resources on tribal state court collaboration publications. And again, here are the next 3 upcoming facilitated discussions. Next month, we will discuss sexual violence and stalking. In July, child violence and sex trafficking. And the last, in August, will focus on the Alaska provisions, as well as habeas corpus and exhaustion of tribal court remedies. And we will send out information on these as the dates get closer. So thank you all for joining today. And as I mentioned, I will send out the information that we covered today with the PowerPoint and links to previous webinars. So thank you all for joining and have a great day.
Also, we will be sharing an evaluation link in the chat box, and we ask that everyone please fill out the evaluation link. Thank you all.